So now I request Ms. Sriharini to give a brief intro about the resource person of this session.
Good morning to everyone present here and honorable dignitaries on the dais and off the dais. Today, we commence with the first session of this 3-day workshop on art of advocacy, and we have the first resource person with us, Senior Advocate PM Subramaniam sir. Sir is a gold medalist in economics from the D.G. Vaishnav College. He enrolled as an advocate in the year 1989. For more than 15 years of practice, he had been a legal advisor and counsel for the Chennai Port Trust. Pursuant to his designation as a senior advocate, he had been made the senior legal advisor of the Chennai Port Authority. Years back, he represented the Madras High Court Advocates Association before the Parliamentary Standing Committee for Legal Reforms. He has now been empaneled as a senior advocate to represent the Registrar General of the High Court of Madras. He had handled different cases in all branches of law and had lectured in the Tamil Nadu State Judicial Academy for judicial officers of the rank of district judges. I deem it my pleasure and honor in inviting Sir to address the gathering on the topic, the art of drafting and pleadings in civil litigation. Over to you, sir. I'm to kindly honor the resource person with a shawl and a memento. Thank you so much, ma'am. Thank you, sir, for coming here with us and being here amidst your busy schedule. I now invite Sir to take over the stage and to deliver a lecture on the topic, the art of drafting and pleading in civil litigation.
Dear students, learned Registrar of the Ambedkar Law University, Mr. Shiva, the office bearer of the MBA, respected teachers of the lecturers, professors of the university. Good morning to one and all. It's been a great pleasure to be in the midst of students and to deliver an address, art of drafting and pleadings in civil litigation. It might look as a very simple subject, but it is not so. Half your case you succeed if you have properly drafted your pleadings. I shall consciously make an endeavor to confine myself only to the rudiments of the subject, only to the fundamentals of the subject, because I strongly believe, and I want every one of you to believe as well, that if your pleadings are proper, are correct, are concise, are precise, then you have marched halfway through success. You must be very careful before finalizing your pleadings. And it is my most sincere request to all the students here that immaterial, whatever be the litigation that you're going to commence, please ensure you do a substantial research in finalizing your pleadings, for that is the spinal bone of your entire pleadings. And you should not, on a later date, in the midst of the proceedings or in the midst of trial, regret that you have made insufficient or incomplete pleadings. As I said at the outset, I will definitely confine myself only to the fundamentals for the entire 1 hour, which I'm going to. Pleading simple, plain or written statement containing a concise form, the material fact on which the party pleads relief for the claim, or that shall include the plain, the written statement, the original application, the reply statement, the rejoinders, the affidavits, the additional statements, the supplementary pleadings, all that is put together pleadings. Now, what are the functions of pleadings? Pleadings are not simply for the benefit of the parties, but it is also primarily to assist the court, primarily for the assistance of the court, to bring precision to the area beyond which a conflict must not be allowed to extend. So you see, the entirety of your case will be confined to the pleadings, and you must ensure that it is advanced in such a manner justice prevails and there is not going to allow multiplicity of litigation. Try to adopt moderation in your language because that is the hallmark of proper pleadings. Most importantly, total clarity is required in your pleadings. It must not be ambiguous, and you should not beat about the bush, make it lengthy, not required. Precise, concise, and clarity should be there. Because pleadings, therefore, are intended to regulate the business and procedure of the court. I would take you to some relevant and important provisions of the Civil Procedure Code to make you fall on track to comprehensively understand the scope in which you should prepare and make your pleadings. We basically rely on the Civil Procedure Code, but please understand it is not substantive law. It is only adjective law, procedural law. But the rights of parties are to be determined only by the substantial law. So what shall be the duty of a lawyer when he starts preparation in making his plaint ready or his written statement ready or whatever is the original script that he wants to file before the court? The first point is that you must first familiarize yourself with the substantive law in the subject in hand, the statute, the judicial precedents. Find out the correct position of law on the matter. Now you will get to know the entire facts of the case from a client and from perusal and understanding of the documents that has been supplied to you, circulated to you or given to you. But you should make yourself familiar with that substantive law in the subject matter, the statute, the judicial precedents, the correct position of law. Then shape your pleading according to the law to the best advantage of your client. You must necessarily have intellectual honesty and place the correct legal position on the strength of your facts. And you must also try to visualize and see how the other side will approach the cause in the case and be prepared for that in your pleadings. And yet another factor will be, please see section 9 of the CPC, the jurisdiction of the court, whether there is a bar to file this particular suit before the competent civil court. Because now you see various special courts have come. Various authorities are there, various tribunals are there to cite, for example, the rent control tribunal, the matrimonial disputes, the debt recovery tribunal, the taxation tribunal, so on and so forth. So first check whether a suit will lie. For example, if you take the HRNC Act, there is a specific bar that you shall not file a suit before a competent civil court, that is under section 108 of the Act, excepting under certain exigencies, certain contingencies, where you try for a declaration of a denomination temple. But minus and plus that for all other proceedings, the HRNC Act, there is a bar to file a suit. So you must find out whether a suit will lie. Even if you take, for example, the Cooperative Society Act, there is another bar under section 156. So please ensure whether the jurisdiction is available to go for a civil suit before you commence your work. Now, I would classify pleadings from all what good authors have done into 5 broad heads. One is pleadings in a suit. Now, as I said at the outset as a threshold, I'm confining myself to the fundamentals because once your fundamentals and your understanding of what exactly should be pleadings and what shall be the larger scope of it, if you have clarity in that, your march towards success in the suit that you propose to file will definitely be higher than otherwise. Pleadings in other civil proceedings before a court or tribunal, pleadings in writ proceedings, pleadings in an election petition, pleadings in a quasi-judicial authorities. Please refer to Order 6, Rule 2, pleadings, which speaks about plaint and written statement. A statement of claim is called plaint. And mind you, cause of action with all necessary particulars. there shall be a last paragraph in the plaint which shall speak about the cause of action. But it shall be prudent on your part to incorporate the cause of action, the reason why you are before this jurisdiction court, in your pleadings in a very skillful manner, for reasons which I'll let you know little later. When you file a written statement for any plaint that has come before you, you must try to, the defendant deals with all the material facts alleged by the plaint and must state new facts in his favor. That under Order 8 Rule 1, when the written statement comes to be filed. So these are the primary two proceedings, primary two. One is the plaint and one is the written statement. Please don't believe in making lengthy, long plaints and written statement. It can be endangering to your interest on a later stage. Many a times, what is said in excess will stand as an obstacle when the trial commences and you will be midway through. That is why I have been repeating the word precise, concise, laconic, brief. For when you, as much as in a relationship, overdoing will definitely end up in disaster. Try, it is not as if I'm asking you to skip certain important aspects. There may be a necessitating moment where in a particular plaint or written statement there must be a lengthy drawn script, draft, but please see that you ensure that you put precisely what is required. You need not have to bring all what you're going to bring it as evidence in your plain pleadings, not at all. Now, no pleading subsequent to the filing of the written statement is permissible. So therefore the plaint and the written statement. But in case of a plaintiff, a replication of the rejoinder is permissible with the leave of the court. In case of the defendant, an additional written statement is permissible with the leave of the court. In circumstances as to how it takes its birth is when the plaint is amended or replication application is filed by the plaintiff to add substance to the already filed plaint. So everywhere, try to see that you are confining yourself with the absolute necessary requirements. I am not asking you to delete and leave away what is required. I am only trying to demonstrate and bring it to your good attention that please speak it as little as you can, as concise as you can. For the objects of pleadings, we give fair notice to each party of the opportunities. The main object of pleadings is to narrow down the controversy between the parties. Now you must understand, contentions which are not based on the pleadings cannot be permitted to be raised at a trial stage or an appellate stage. So merely because the speaker is telling you try to be precise, try to be concise, doesn't mean you will have to delete certain absolute necessary requirements. Because you may not be permitted, you will not be permitted at a later stage. But you see, there's a paradox. The law says, legal precedent says, judgment says, the evidence, if any, produced by parties cannot be considered if there are no pleadings. You cannot travel beyond pleadings. So you cannot let in evidence when there is no plea or pleadings as far as that is concerned. Now this is governed by so many judgments. The two important judgments which you can note down would be AR 1987 Supreme Court 94 and AR 1989 Supreme Court 1530. There are so many judgments thereafter, but these judgments will throw substantial light, though they are a little early than the meaning. Now this will go to say that your evidence that whatever you propose to let in or what you let in the trial cannot be considered by the court if they travel beyond the pleadings. The pleadings is therefore the beginning and the end of your claim in the suit. But you see a small paradox here. If in the absence of pleadings, issues are framed by the court, the court for some reason has framed issues in the absence of pleadings. The parties who are conscious of the fact that there is no pleading, but the court has framed issues, you go on trial, adduce evidence, That has culminated in a degree. Now you cannot take a plea of objection in an appeal that it is not contained in the pleadings. The issue has been framed. So therefore, these are things which are little tricky. What I said little earlier will be inconsistent to what I'm saying right now. What I said little earlier was that if evidence, if any, produced by parties cannot be considered if there is no pleadings in support of that. Now I tell you, relying upon 1999 3 Law Weekly 466 Supreme Court, 1999 3 Law Weekly 466 Supreme Court, which is contrary to the earlier proposition that I gave to you, is when issues are framed even without pleadings, even in the absence of pleadings, and you submit to those issues and go ahead with the trial, adduce evidence that is culminated in a degree. Now you cannot take a plea that it is not available in the pleadings, therefore it is not permitted. That issue cannot be framed, that cannot be taken in appeal. When you come for the defendant, you must please understand a plaint has to be read as a whole. Please don't read plaint they cannot be compartmentalized, segregated, and you cannot piecemeal it. The plaint has to be read as a whole. The plaint, if read as a whole, will give you a substantial perspective as to how to take a defense, your defense, in the written statement. Pleadings definitely is an art. If your written statement is an endeavor to put forth the facts from your end, from the end of the defendant, nothing wrong about it. But please bear in mind, the facts that the defendant intends to put in his written statement should necessarily cover the plaint as a whole that has been placed before him. A mere simplistic denial, I deny what the plaintiff says, is not going to help you. Your denial should be supported by necessary material, factual material, and if possible, if you have evidence, you can just make a marking sentence that this evidence is available. So what then would be the fundamental rules of pleadings? Every pleading states facts and not law unless required by statute. You can state the statement of facts in a very chronologically correct manner. You can correlate one after the other in a sequence which is appreciable, desirable. And even if you do not state the law, the court will take care of that, or it is always open to you to place a legal position in support of your pleadings. But unless when a law required, when a statute requires to spell out the law, material facts and facts alone, that is what Order 6 Rule 2 says. And try to say only the facts in which the party relies upon, the plaintiff relies upon, and not the evidence which can be proved at the time of trial. You need not have to say one particular document you're relying upon and then keep speaking about it in your plain pleadings. You can merely make a reference to it. For example, if there's an agreement, you can merely make a reference to that agreement. Your right originates from this agreement, which is a document before court. Now, what is the scope of that agreement? How one has to construe the validity of the agreement? All this can be looked into at the time of trial. So facts concisely, precisely, in precision. Please understand, please bear in mind, if you make bad pleadings, it can be fatal to your case. That is why I keep saying, please don't overdo. Please remember this one word, overdoing. It might help you in your personal life as well. Please don't overdo. Do what is required. Don't do in excess of what is required. My friend here, I'm asking you a question. You eat your food for lunch. You overeat, what happens? This is exactly what happened. These bad pleadings, you see, you must understand, when I have already told you this is not substantive law, this is an adjective law, or in your words, procedural law. But in those days, that is in 1860, when the CPC was framed, you did not have many laws. The common law prevailed, judge-made law prevailed, there were very few statutes. Even in 1908, when the CPC saw, are you in a position to hear me? In 1908, when the CPC saw its amendment, even then there were not much special laws, special statutes. Everything was judge-made. But in 1999 amendment, or the present CPC as you have on your table today, laws are multiplied, multifold. A number of laws. And some of the laws, of course, are special laws, and there's a special course of remedy available to you. You need not have to come to civil litigation. I'm confining my talk to civil litigation because that's what has been given to me. But by reason of the fact multiple laws have come into stay, you must necessarily see that you understand the law which you are now trying to deploy in seeking remedy. 1860 முதலாக சிபிசி வரும்போது இந்த நாட்டில் ஆங்கிலேயர் ஆட்சியின் போது 1908 இப்போ 1999க்கு அப்புறமும் சிபிசி வந்து பல்வேறு ப்ரொசீஜர் நமக்கு தந்திருக்கு. பட் அந்த காலகட்டத்தில் அவ்வளோ சட்டங்கள் கிடையாது. பட் டுடே இன்னைய நிலைமையில் நிறைய சட்டங்கள் வந்துடுச்சு. மல்டிப்ளைட் லாஸ், மல்டிஃபோல்ட் லாஸ் ஹவ் கம். அதனால் நம்ம ஒரு கேஸ் எடுத்து நடத்துகிறோன்னா, அதுக்கு ஒரு பிளெயிண்ட்டை தயார் செய்கிறோன்னா, அந்த ஃபேக்ட்ஸை ஃபுல்லாக நம்ம கேதர் பண்ணிவிட்டு, இந்த ஸ்பெஷல் லாவோ இந்த புதுசாக வந்த சட்டமோ இல்லை இதுக்கு எந்த சட்டம் பொருந்துங்கிறது பார்த்துட்டு அந்த சட்டத்தை ரொம்ப மெட்டிகுலஸாக உன்னிப்பாக ஒரு பிரிவையும் அதை பார்த்து அதில் உள்ள சாராம்சத்தை நன்கு உணர்ந்துட்ட பிறகு தான் நம்ம பிளெயிண்ட்டை தயார் பண்ணணும். அதுதான் ப்ளீடிங்ஸ். மனசுக்குள்ளே நம்மளே ஏதாவது நினச்சிக்கிட்டு இல்லை இப்படி இருக்கும் அப்படி இருக்கும் லாஜிக்கலாக இப்படி இருக்கும், ப்ளீஸ் ஒன் அப்ளை லாஜிக்கலாக இப்படி இருக்கும்னு சொல்லிட்டு எந்த விதமான ப்ளீடிங்ஸும் தயார் பண்ணக்கூடாது. See what need not be pleaded, what should be pleaded. For example, in those days, I'm talking about the pre-independent era, where Jains in India, excepting Madras and Punjab, the widows were having the authority without the husband's authority to adopt. Whereas in these two places, the widows did not have the authority. You need not have to say that because it is presumed and it need not be pleaded. Why I am drawing this one-line example is that what is presumed, what is established, what is prevailing, what is accepted, what is the law that governs, you need not have to plead all that. But when you plead limitation, when you plead for limitation, there must be a very categorical, clear sequence of narration that has to be given to show and demonstrate that it suffers from limitation or it is not suffering from limitation. Limitation ஒன்று எடுத்தீங்கன்னா இந்த தாவா வந்து நம்ம தாக்கல் பண்ண முடியாது, இல்லை எதிர்கட்சிக்காரன் தாக்கல் பண்ணது வந்து தப்பு அப்படின்னு எடுத்தீங்கன்னா சும்மா வந்துட்டு இட் இஸ் பார்ட் பை லிமிட்டேஷன் அப்படின்ட்டு ப்ளீடிங் எடுக்கக்கூடாது. யூ மஸ்ட் எக்ஸ்பிளைன், யூ மஸ்ட் சே, நீங்கள் சொல்லணும், எக்ஸ்பிளைன் பண்ணணும் ஏன் அது லிமிட்டேஷனால். பிகாஸ் லிமிட்டேஷன் எங்கே கமெண்ட்ஸ் ஆகுது, எங்கே ரெக்கன் ஆகுது, எங்கே தொடங்குது, அதை உன்னிப்பாக கவனிக்கணும். 3 இயர்ஸ்ன்னு சொல்லுவாங்க ஒரு சூட்டுக்கு 12 இயர்ஸ்ன்னு சொல்லுவாங்க ஒரு சில அப்போ எங்கே இந்த 3 இயர்ஸ் ஸ்டார்ட் ஆகுது, எங்கே இந்த 12 இயர்ஸ் ஸ்டார்ட் ஆகுது. All these things you will come to know only when you work hard and do your research. I repeated, I must be excused for repeating, please do substantial homework before you take your pen and start your preparation. Pleadings is not to be done in a slipshod method. Because your slipshod pleadings, take it from me, will land one day into a fatal end. Many a case is lost because of negligence, slipshod, lethargic drafting being done without applying what is required to be applied, both law and the legal procedures, the judicial proceedings. No man is born with knowledge. Every man acquires knowledge. This is a profession where if you keep studying, if you keep reading, if you keep understanding what you read, and most importantly, you keep applying what you have read in manner as is required, then the chances of your success are very, very bright. I mean success not only in your profession, but success in your cause and case. Limitation on எடுக்கிறோம்னா limitation எங்கிருந்து தொடங்குதுன்னு பார்க்கணும். 3 ஆண்டு லிமிட்டேஷன் இருக்கு, 12 ஆண்டு லிமிட்டேஷன் இருக்கு. நான் இன்னும் மெட்ரிக் ஒரு சப்ஜெக்ட்டுக்காக போக விரும்பலை. ஆல்ரெடி வி ரன்னிங் ஷார்ட் ஆஃப் டைம். அது எங்கேருந்து தொடங்குதுன்னு பார்க்கணும். 3 வருஷம், எஸ் டேட் ஆஃப் அக்ரிமெண்ட், கமான் 3 இயர்ஸ், அந்த மாதிரி ஒரு டக் ஸ்ட்ரைட் ஜாக்கெட் கன்க்ளூஷன்ஸ் இன்ஃப்ளூயன்சஸ் வரக்கூடாது. எல்லாருமே அதை யோசிக்கணும். இது எப்படி எங்கேருந்து தொடங்குது, எப்போ முடியுது, எங்கே பார்ட் பை லிமிட்டேஷனுங்கிற கான்செப்ட் நம்ம கொண்டு வர முடியும். இதெல்லாம் பெரிய விஷயம் இல்லை. இல்லை கொஞ்சம் ஹார்ட் ஒர்க், கொஞ்சம் ஆராய்ச்சி, கொஞ்சம் கவனமாக என்னென்ன இருக்குது, என்னென்ன மெட்டீரியல் இருக்குது, எங்கே தொடங்குது, எங்கே முடியுது பார்க்கணும். நான் ஒரு எக்ஸாம்பிள் சொல்கிறேன். இப்போ ஸ்பெசிஃபிக் ரிலீஃப் ஆக்ட் எடுத்துக்கோங்க. எல்லாருக்கும் தெரியும், ஆல் ஃபினிஷ்ட் அ ஃபைனல் இயர். த மோஸ்ட் இம்பார்ட்டன்ட் லைன் இஸ் plaintiff must allege he was ready and willing and is still willing to perform his contract, his part of the contract. I will just read that one section. ஒரு செக்ஷன் கூட நான் படிக்கல, ஒரு செக்ஷனில் இருக்க ஒரு சப்செக்ஷன் மட்டும் படிக்கிறேன். செக்ஷன் 16 subsection C. That he has performed or always been ready and willing to perform the essential terms of the contract which are to be performed by him, other than terms of performance for which he has been prevented or waived by the defendant. So the ready and willingness பார்க்கும்போது, ready and willingness, that is one thing. The second aspect is still willing. I'm still, there is a act in continuity, continuous act, still willing. அது அல்லாமல் you must see that word, நான் வில்லிங்காக இருக்கிறேன் to perform my part of the duty, my part of the obligation under the contract. But the defendant அதை prevent பண்ணுறாரு. நான் பணத்தை கொண்டு போய் கொடுக்குறேன், அவர் வாங்க மறுக்கிறார். Because all these things has to be categorically established in your pleadings. நான் பணத்தை கொண்டு போய் கொடுக்க போனேன், இன்னார் முன்னாடி கொடுக்க போனேன், இந்த தேதியில் கொடுக்க போனேன், இந்த இடத்துல கொடுக்க போனேன். டிராஃப்ட் சேல் டீடை கொண்டு போய் கொடுக்க போனேன், இன்னார் முன்னாடி கொடுக்க போனேன், சப்ரேஸ்டர் ஆஃபீஸ்க்கு வாங்கன்னு சொல்லி தேதி குறித்து கொடுத்தேன். So you must try to see that this leg of this section is brought within the scope of your pleadings under the parameters of your factual position. A factual position is mentioning the date, mentioning the time, mentioning the occasion, mentioning before whom you propose to give that money and how you were prevented by the defendant. Therefore, you seek relief under 16C. So this, you see how pleadings plays a vital role at every single stage of your இப்போ damages எடுத்துக்கிட்டிங்கன்னா there is general damages and there are special damages. Of course, general damages is when the law presumes and the consequences, the law presumes to be natural and the law comes to protection. Let me go into special damages where the laws as the law will not presume to be the consequence of the Defendants Act, but will depend on the circumstances of the case. So, the loss incurred as a result of the defendant's action, அதனால தான் special damages. Defendant actionனால என்ன loss ஏற்பட்டதுக்கு முன்னாடி Defendant or action in action. What was the action of the defendant that has caused injury to you? When it was caused, how it was caused, segment number 1. How it was caused, when it was caused, segment number 1. Such causation of injury has put you to loss. Therefore, you come for special damages. எப்போ இந்த லாஸ், எதனால லாஸ், எந்த சந்தர்ப்பத்தில் ஏற்பட்டுச்சு, எந்த சூழ்நிலையில் ஏற்பட்டுச்சு ஒரு பக்கம் இருக்க போகி, அடுத்ததாக இந்த லாஸ்னால, இந்த இன்ஜுரினால உங்களுக்கு என்ன லாஸ் ஏற்பட்டது, டிஃபெண்டன்ட் உங்களுக்கு காஸ் பண்ண இன்ஜுரியால் உங்களுக்கு என்ன லாஸ் ஏற்பட்டுச்சு. ஸோ இதெல்லாம் ப்ளீடிங்ஸில் அலெஜ் பண்ணும், இன்கார்பரேட் பண்ணும், ஸ்டேட் பண்ணணும். அதுவும் ரொம்ப சிம்பிளாக, கன்சைஸ், ப்ரிசைஸ். ஐ எம் repeating it repeatedly. You see, we are living in a very fast world. You go to any sitting judge, not only before the High Court, before the District Court, before the Sub Court, before the Municipal Court, you look at the volume of work they are having. If people are going for court visits, are you? Look what is on board for each judge in the Madras High Court. Do you expect a judge to read every particular line and page of what you are submitting before him? So is it not your duty, or the duty of all of us, to ensure that you try to place it in a brief and a concise manner? For absolute want of time, சாதாரண முனிசிபல் கோர்ட்டு போனால் கூட பிளைண்ட் எடுத்துக்கிட்டு முனிசிபல் கையில் வந்து 60 பக்கம் பிளைண்ட்டை கொடுக்குறாங்க. Of course, the case comes to an end after the full-fledged trial takes place. All the evidences are let in. All that is a different issue. But the court wants to discharge its first duty by seeing what is contained in the plaint. But do you expect a municipal to read a 60 pages plaint or a 70 pages written statement? It is being done day in and day out in Mafsal courts. I am not trying to say in all cases, in many cases. So there are certain things you must understand. For example, there is a reference to condition precedent in CPC. For example, Section 80 CPC notice is a mandatory notice to be sent if the respondent defendant is a government, and you want to weigh that, you must spell out reasons. Plaint draft பண்ணும்போது சின்ன சின்ன விஷயங்கள் தான். பேர் எழுதும்போது மதனகோபால், ஜே மதனகோபால், ஜே கரெக்டாக இருக்கா, மதனகோபால் கரெக்டாக இருக்கா? இப்போ எஸ் மதனகோபால் நீங்கள் போட்டால் என்ன ஆகும்? மதனகோபாலோட அப்பா பேரே அப்பாவே மாற்றிட்டேங்க. மலீஷியஸ் ஆகிடுது, ஸ்கேண்டலஸ் ஆகிடுது. அந்த டிஃபென்ஸ்லாம் இருக்குது. கேர். From more than one record, find out what Madanagopal he is. Try to be accurate. And please don't deploy that word ifs and buts in your drafting. If this happens, if that happened, but this happened, Vanda, ifs and buts, this hypothetical situation, the court is not here to find out all these hypothetical, do all the research on hypothesis and then come to conclusion. It is expecting factual placement of facts to draw inference, to come to conclusions. If this happens, if that happens, try to be bold and try to be plain. Fear none. Try to be bold in a plaint. This is what has happened because it is a statement of fact. உண்மையை சொல்றதுக்கு அஞ்சவே தேவையில்லை. It's a statement of fact. Certain people, தமிழ்லையும் நான் டிராஃப்ட் படிச்சிருக்கேன், இங்கிலீஷ்லையும் படிச்சிருக்கேன், காம்ப்ளெக்ஸ் சென்டென்சஸ் போடுறாங்க. காம்ப்ளெக்ஸ் சென்டென்சஸ். இந்த காம்ப்ளெக்ஸ் சென்டென்சஸ் என்னன்னா, அது சம்டைம்ஸ் வந்து எரர் க்ரீப் ஆகும். நமக்கு knowingly it creeps in or unknowingly it creeps in. Try to avoid making complex sentences. Some of the best authors that I have read so far, I see their writing is simple and everybody understands that. Some of the most heavily read books throughout the world, not only in law, in literature, are simple written, simple language. And you also try to avoid repetition. Sometimes unknowingly we will be repeating things. This happens only if you are mentally making, getting yourself prepared to make a long drawn draft. Then you repeat. Nobody relishes repetition. And let me also tell you one more danger in repetition. நீங்கள் ரிப்பீட் பண்ணும்போது முன்னாடி சொன்னதுக்கு சற்று முரண்பாடாக கூட ரிப்பீட் பண்ணுவீங்க with distortions. a departure from exactly what you have said earlier, then what happens? You give way to the defendant to take a defense that these cannot coexist. Repetition பண்றீங்க முதல்ல சொன்ன வாசகத்துக்கும் ரிப்பீட் பண்ணி சொல்ற வாசகத்துக்கும் முரண்பாடு ஏற்படுது, கொஞ்சம் டிஃபரன்ஸ் ஏற்படுது. ஸ்லைட் முரண்பாடாக இருக்கலாம், பட் இட் ஹேஸ் மெட்டீரியல் எஃபெக்ட். உடனே டிஃபென்ஸ் எடுப்பாங்க ரிட்டர்ன் ஸ்டேட்மெண்ட்லேயோ இல்லை எதிர்மனாதர். இதுவும் ரெண்டும் கோஎக்ஸிஸ்ட் ஆகாது, ரெண்டுமே சேர்ந்துருக்க வாய்ப்பு இல்லை. ஸோ ட்ரை டு பி ஸ்பெசிஃபிக். அதே மாதிரி ரிட்டர்ன் ஸ்டேட்மெண்ட் பண்ணும்போதும் blind, I deny all the allegations that is contained in the plate except that which are specifically admitted here. இதெல்லாம் வேண்டாம், இதை பண்ணணும். You must specifically say why you deny. For example, execution of a pronote, சும்மா அதை நான் blanket denial முதல்ல கொடுத்துட்டேன், I deny all the allegations. That is not how the court will appreciate it. The court will ask, it is your signature, you have executed it on this given date. They say consideration has been given to you, money has been given to you. No, I have denied it. That will not help you. You must try to be very specific. அதே மாதிரி இன்னொரு crucial area. If you take the judgments, judicial precedents, the fraudங்கிற வார்த்தை நம்ம 1950 1975 வரைக்கும் பார்த்தீங்கன்னா ஃப்ராடுங்கிற வார்த்தை ரொம்ப ரேராக தான் ஜட்ஜ்மெண்ட்ஸில் பார்க்க முடியும். 1975 to 1990 வரைக்கும் பார்த்தீங்கன்னா ஜட்ஜ்மெண்ட்ஸில் ஃப்ராடு கொஞ்சம் அங்கங்கே 2000 மேலே ஃப்ராட் வந்து இஸ் கம் டு ஸ்டே. ஸோ வென் யூ allege fraud, from mere suspicionல வந்து you cannot allege, it is not enough. You must give thorough details of the alleged fraud. Clear case of fraud should be made out on the facts supplied. You cannot presume, you cannot assume, you cannot come to your own conclusion and then, like say this is a suspicious nature in which this transaction has taken place. Therefore, I am trying to say it's fraud. No. Fraud, if you wanted to see in IPO, you take section 17 of the Contract Act. It will come to your help with a clear definition. See, I will just read 17A. I'm not going to trouble you by reading many a section here. A person who knowingly himself not to have any title of the property has contracted to sell the property or let the property. When you read these sections, you get to know the spine ingredients required. A person who knowing himself that he does not have title to the property has contracted to sell or let the property. You see what is fraud under 17A of the Contract Act. Now, when you draft your pleadings, when you allege fraud, it must be meticulously explained as to how this person, with the fullest knowledge, has committed this act which amounts to fraud. You must set out all details. The act which is done with malevolent intention is to deceive the person. இப்போ நீங்கள் undue influence எடுத்துக்கோங்க. ஃப்ராடுன்னு தமிழ்லையும் சொல்கிறேன். ஃப்ராடுன்ட்டு நீங்கள் சொல்லும்போது அதை கேர்ஃபுல்லாக சும்மா நான் சஸ்பெக்ட் பண்ணுறேன் இது ஃப்ராடாக இருக்குமா அப்படிலாம் கிடையாது. எப்படி ஃப்ராடு, எதனால் நீங்கள் ஃப்ராடுன்னு சொல்கிறீங்க, இந்த ஃப்ராடு கமிட் பண்ணவர் என்ன உள்நோக்கத்தோடு பண்ணார், எவ்வாறு பண்ணார், எப்படி பண்ணார், இதனால் என்ன பாதிப்பு ஏற்பட்டுச்சு. இப்போ coercion எடுத்துக்கிட்டானா கூட you can rely upon a definition from the Contract Act. Committing or threatening to commit any act forbidden by IPC. Forbidden. So that is by what now today you have a different code. It is a Bharatiya Nyaya Sanhita BNS. Try to get yourself acquainted with all these things. The new laws that has come to stay. And there are certain words which if some of you who are interested may note down these words and try to do some research on your own score, that may definitely help you to understand, to widen your spectrum about concepts which you will try to, words, nomenclature, concepts which you will try to deal with in future. நான் சொல்கிற சில வார்த்தைகளை நீங்கள் நோட் பண்ணி வச்சுக்கோங்க. அந்த வார்த்தைகள் சம்பந்தப்பட்ட சட்ட லிட்ரேச்சர் எதுவாக இருந்தாலும் சரி, சட்ட புத்தகம் எதுவாக இருந்தாலும் சரி, உங்களால் முடிஞ்ச நோட்ஸை ட்ரா பண்ணிக்கோங்க. இந்த வார்த்தைகள், அதோட அர்த்தம், அதோட கான்செப்ஷுவல் மீனிங், இது வந்து நீங்கள் பண்ண போகிற டிராஃப்ட்டும் நீங்கள் பண்ண போகிற கேசஸுக்கும் விரைவில், பிகாஸ் யூ ஆர் ஷார்ட்லி டு பி என்ரோல்டு, அது பயன்படும். கொல்யூஷன், misrepresentation, mistake, negligence, medical negligence, breach of trust, agreement. உங்களுக்கு பார்க்க சிம்பிள் வேர்டாக இருக்கும், அதுக்கு நிறைய மீனிங் இருக்குது. அக்ரிமெண்ட், அது நீங்கள் படிக்கும்போது உங்களுக்கு தெரியும். ஈஸ்மெண்ட், easement is available by grant, easement is available by prescription, easement is available by statute. I'm not going to all that. You note down this word. Adoption and adverse possession. See, for example, now that I let me just tell you one word, adverse possession. You must allege how when adverse possession commenced. சும்மா 12 வருஷம் adverse possession அது இல்லை. That is not your pleadings. When did adverse possession come? One segment, one aspect. When was the fact of adverse possession known to the real owner? Another aspect. இந்த சொத்தின் உண்மையான உடையக்காரருக்கு எப்போ தெரிய வந்தது? ரெண்டாவது ஆஸ்பெக்ட். எப்போ adverse possession commence ஆச்சு? Reckoning the 12 years as contemplated in law can't be done on whims and fancies of anybody and everybody. A good lawyer will break a case into pieces if adverse possession, perfecting title by adverse possession is prayed for without meticulously explaining each and every aspect required for this particular suit proceeding. That is why I said pleadings must be very, very carefully done. இப்போ பார்ட் பர்ஃபார்மன்ஸ் பண்ணிட்டாங்க, ஸ்பெசிஃபிக் பர்ஃபார்மன்ஸில் 53A ப்ராப்பர்ட்டியோட பொசஷன் கொடுத்துறாங்க, வருஷம் 20 வருஷம் ஆகிப்போச்சு. கேன் தட் பர்டிகுலர் பர்ச்சேசர், ப்ரப்போஸ்ட் பர்ச்சேசர் சீக் ஃபார் அட்வர்ஸ் பொசஷன்? ஹவு, வென்? If you people feel that you can seek, because 20 years ஓடி போச்சுன்னா, then you please make out a case by specific pleadings that the landlord, the abandonment, the landlord, the original owner has not come into the picture. All these things are required. More and more you get into the subject by research, by study, you'll get to know. See, for example, when you deal with the matter in Transfer of Property Act, in your suit pleadings, 4 important sections, very simple section, 5, 6, 7 and 8. Transfer of property, what may be transferred, persons competent to transfer and operation of transfer. 5, 6, 7 and 8. When you get a skeletal idea of the subject in its entirety, and that will facilitate and enable you to make a good plaint. Your pleadings will be rich to sustain the relief sought for. நார்மலாக எல்லாரும் சொல்லுவாங்க டிக்ளரேஷன் ஆஃப் டைட்டில் கேட்டுட்டு கான்சிக்வென்ஷில் பெர்மனன்ட் இன்ஜங்ஷன் கேட்கணும். இந்த ப்ளீடிங்ஸ் வந்து பெர்மனன்ட் இன்ஜங்ஷன் சூட்லேயோ இல்லை இன்ஜங்ஷன் அப்ளிகேஷன்லேயோ ரொம்ப கேர்ஃபுல்லாக இருக்கணும். It is a purely discretionary remedy vested with the court. But the court in all its wisdom will look into all the pleadings and the materials available before you before a grant of injunction, either ex parte or even after contest. It is not necessary a declaration should proceed in all matters and a permanent injunction is prayed for as a consequential relief. If there is no dispute at all to title, a declaration need not be prayed for. And how does a court come to a positive conclusion and inference there is no dispute at all regarding title? It will be on the strength of your pleadings. Your pleadings should make it very, very clear, categorically clear, without any doubt, that there is no dispute at all by any side, much less the defendant, regarding the title. Then the permanent injunction can stand on its independent legs. பெர்மனன்ட் இன்ஜெக்ஷன் மட்டும் ரிலீஃப் கேட்க முடியுமா, டைட்டில் டிக்ளரேஷன் கேட்காம அப்படிங்கிற ஒரு சுச்சுவேஷன் வரும்போது, டைட்டிலில் எந்த விதமான குறைபாடும் இல்லை, யாருமே டைட்டிலை டிஸ்பியூட் பண்ணல, இல்லை டைட்டிலை டிஸ்பியூட் பண்ணுறதுக்குள்ள ஒரு ஸ்கோப்போ மெட்டீரியலோ இல்லை டிஃபெண்டண்ட்டுக்கு. சும்மா டிஸ்பியூட் பண்ணுறது டிஸ்பியூட் இல்லை, தனக்கு தான் அந்த சொத்து சொந்தம்னு சொல்கிறதுக்கும் அவனுக்கு மெட்டீரியல் இல்லை. Then the title is established. Even defendant வந்து இவங்களுக்கு டைட்டில் இல்லைன்ட்டு பிளாங்கெட்டாக சொல்கிறது எந்த கோர்ட்டு ஒத்துக்காது. ஏன் டைட்டில் இல்லைன்னு சொல்லிட்டா உனக்கு எப்படி டைட்டில் இருக்குன்னு 2 கேள்வியும் கேட்பாங்க. ஆக டைட்டிலில் எந்த விதமான பிரச்சனை இல்லாத போது டைரெக்டாக பெர்மனெண்ட் இன்ஜெக்ஷனுக்கு ப்ரே பண்ணலாம். ஆனால் அவ்வாறு ப்ரே பண்ணும்போது அந்த ப்ளீடிங்ஸை வந்து கேர்ஃபுல்லாக கரெக்டாக பண்ணணும். இப்போ டுடே I come to a very interesting aspect of if any of you are having the new act, the Bharatiya Shaksha Adhiniyam எனக்கு இந்த pronunciation கூட ஒன்றும் வரல. அதில் take section 57 and 58 if anybody is carrying books, you can take it from you. In the 57 and 58 வந்து 2 primary evidence, secondary evidence. We are now in pleadings. I have gone to the Evidence Act, and you may ask me why. This 57 was the original 62 under the old Indian Evidence Act, and this 58 is the original 63. I'm talking about primary evidence and secondary evidence. There is not at all any difference, excepting the fact that about this electronic evidence admissibility. If you have a document which falls within the ambit of secondary evidence and that alone is available with you, please craftfully bring it in your pleadings. பிளெயிண்ட்டை தயார் பண்ணும்போது நம்மள்ட்ட இருக்கிற டாக்குமெண்ட் எல்லாம் சர்டிஃபைட் காப்பீஸ் தான். சர்டிஃபைட் காப்பீஸ் அண்ட் விச் இஸ் கிவன் பை ஆத்தென்டிக் அத்தாரிட்டி, பட் ஒரிஜினல் இல்லை, ப்ரைமரி எவிடன்ஸ் இல்லை. அப்போது எந்த காலகட்டத்தையும் நமக்கு வந்து இந்த ப்ரைமரி எவிடன்ஸ் கிடைக்க போதில்லை, சர்டிஃபைட் காப்பீஸ் தான் நம்ம வண்டியை ஓட்டணும்னா அதை ப்ளீடிங்ஸில் தத்ரூபமாக அழகாக ரத்தின சுருக்கமாக கொண்டு வந்துடணும். So that nobody tomorrow can raise a question in the defense. So therefore, please read these sections and try to see how best you can safeguard your interest for the trial. Now, I would only request you to take 2 important sections in CPC. One is Order 16, Rule 6. Another is, Order 6, Rule 16. When you take Order 6, Rule 16, which talks about the striking out pleadings, in the Order 6, Rule 16, Order 7, Rule 11, rejection of plaintiff. The 2 proceedings, please ensure that your pleadings falls within the specific parameter of the contingencies contemplated in the section. For example, let me first start with Order 7, Rule 11 for rejection of plaint. A plaint shall be rejected in the following cases: where it does not disclose a cause of action. Categorically try to state in your pleadings as to what the cause of action that has been raised by the plaintiff and why you seek a rejection saying that it does not disclose a cause of action. நான் பணம் கொடுத்தேன் வச்சேன் போனேன், that is not cause of action. Cause of action should be very specific, very clear, very categorical. Then B, where the relief claimed is undervalued and the plaintiff on being required by the court to correct the valuation. C is a relief claim in property valued, but the plaint is written under paper insufficiency. Leave that. D, the suit appears from the statement in the plaint to be barred by any law. So now you see, then you have E and F. Under what category, if you see that you had made out a case seeking for the indulgence of the court to reject the plain, please bring your case within the ambit, within the parameters of one of these ingredients. Cause of action illa, it is barred by law. அதை narrate பண்ணுங்க. Narrated in such manner, English ஒரு word சொல்லுவாங்க, irresistible acceptance into. ஸோ நீங்கள் எந்த பண்ணாலும் அதை வந்து இந்த சட்டத்துக்கு உட்பட்டு, அதே மாதிரி நீங்கள் வந்து ஸ்ட்ரைக்கிங் அவுட் ப்ளீடிங்ஸ் பண்ணும்போதும் Order 6 Rule 16 போகும்போது the court may at any stage of the proceedings order to be struck out or amended any matter in any pleading. Then, so I don't want to keep repeating things, but I'm only trying to establish the fact that enormous care should be taken. அதே மாதிரி amendment of pleadings எடுக்கும் போதும் please say care is taken, cautious care is taken. Because amendment cannot be allowed at any stage. Can be allowed till the trial commences. And once the trial commences and then also amendment is available, then you come before the court and say, with all my due diligence, I did not get this material, now only I got it, therefore permit me to amend it. Let us not go to this exigency. So everywhere you see, categorical expression of the matter is required. Now, I am now made to understand there is a time constraint as well. But given another 10 minutes that is allotted to me, I would try to say, தயவு செய்து inconsistent please எடுக்காதீங்க. ஒரு ப்ளீக்கும் இன்னொரு ப்ளீக்கும் கன்சிஸ்டன்சி இல்லைன்னு எடுக்காதீங்க. ஃபார் எக்ஸாம்பிள் சின்ன சின்ன விஷயங்கள் நான் எல்லாம் சொல்லுவாங்க, அன்சவுண்ட்னஸ் ஆஃப் மைண்டு, அன்டியூ இன்ஃப்ளூயன்ஸில் இந்த மாதிரி ஆக்ட் பண்ணிட்டேன். அன்சவுண்ட் மைண்ட் இருக்கிற ஒரு ஆள்கிட்ட போய் எப்படி நீங்கள் அன்டியூ இன்ஃப்ளூயன்ஸ் பண்ண முடியும்? ஒருத்தர் அன்சவுண்ட் மைண்டு, அவர் ஒன்றும் நல்லது கெட்டதே தெரியாது, என்ன பண்ணுறோன்னு தெரியாது. How can that, then you see they are mutually destructive. So you must be very careful. அதே மாதிரி இன்டெலிஜென்ட்டாக ப்ளீட் பண்ணும். I will just give you an example, easement of necessity, easement of prescription, which you must have studied. Easement of necessity, creation of the operation of law. See, for example, when the owner has got two parts of the property, he severs one part, and so that the access for the other person can be through this. Easement of prescription is somebody who is uninterruptedly holding the possession of the property, hostile to the interests, hostile and adverse to the interests of the original owner, adverse for 20 years. So these are two diametrically opposite easementary rights. But you can plead, alternatively be pleaded in intelligent drafting. Either this or that. This alternate plea is also available in law. அதே மாதிரி உங்களுக்கு right of preemption, அதையும் நீங்கள் படிச்சிருப்பீங்க. That is the right which grants and gives you the first opportunity to purchase if the seller chooses to buy. It is ரொம்ப simple. I am there as a co-owner, எனக்கு தான் first opportunity தரணும், ரொம்ப simple. But even there, try to explain how your right opens. How is this right which has opened, you are now making a demand, that my right of preemption should be fulfilled. அதே மாதிரி must be little careful. And I will just rush through, because of want of time I don't want to go into the finer aspects of what I thought I will give you. In suit on contract, suit for specific performance, ejectment suit, suit for partition, suit for bare injunction, representative suits, mortgage suit, section 92 suits, for the person interested in trust. There are different natures of suit. Each suit, please remember, you cannot alter the character of the suit that you have laid. You go under section 92 suit, the person interested in the trust is seeking some remedy. He must be a person interested in the trust. You cannot alter the plain pleadings that we have been, the very color, character of the plain pleading cannot be altered. If it is a case of partition, everywhere the basic structure of the suit cannot be altered. I just not given you this amendment, scope for amendment, scope for deletion, all these things. So I repeatedly tell you, because you are students and I was also a student myself and I'm still a student otherwise, Please remember that not all things can be altered. Not all things can be undone. These are words, if you remember very deeply, would be helpful in multiple facets. Many things can't be undone in this world. So much so your plaint can also not be undone. There is scope for amendment. There is scope for deletion of certain paragraphs in your plaint. All these things, and the CPC comes to your rescue. But with all that I'm telling you, you, for example, in an ejectment suit, or for example, in a specific performance suit, your deletions or amendments or additions cannot alter the very character or structure of the suit itself. So therefore, please bear all these things in mind and try to see that you take as much as possible care that you otherwise can take and ensure that you give the best within you to give what otherwise shall be a pleading, a draft for a plaint or a written statement or for a replication or rejoinder for an amendment, for an application, for whatever it is. See that. Please don't do slipshod work. Please don't do slipshod work. I tell you today, a person who will do a slipshod work will definitely not succeed in this profession. It's not a curse. It's a statement of fact. And what I mean by slipshod work, senior, this is not how you should function. You are betraying your client. You are letting down your client. Your acts will turn fatal. ஒரு முக்கியமான வார்த்தை வாசகம் சென்டென்ஸ் மிஸ் ஆகிடும். சொல்ல வேண்டிய முக்கியமான ஒரு சென்டென்ஸை கம்ப்யூட்டரில் தட்டிக்க மாட்டாங்க. ஒன்று எது சொல்லக்கூடாதோ நம்மளே அன்கான்ஷியஸாக சப்கான்ஷியஸாக ஃபார் சம் ரீசன் நம்ம சொல்லியிருப்போம். அதை கொஞ்சம் உட்கார்ந்து படித்து ஆராய்ச்சி பண்ணுவோம். ஐயோ இது சொல்ல வேண்டாம். I am not asking you to suppress facts before the court. I am not asking you because intellectual integrity will definitely take you a long way. If the court comes to a conclusion at some point of time in a career, this man's intellectual integrity is par excellence, you take it from me, your success rate will definitely be there. Whatever you said will be blindly taken by the court on the face of it. That is not what I'm trying to tell you. But what I'm trying to tell you is that in these contract matters, in these specific performance matters, in these ejection suit matters, in so many matters which I've told you, sometimes what need not be said should not be said. It is not as if it amounts to suppression. I am trying to tell you that the intelligent lawyer will ensure that his drafting is made in such manner, the statement of facts in his precise manner, in his concise manner is placed with integrity, with truth, to what minimum it should be said with an ultimate intention to succeed in the suit for the benefit of his client. But the endeavor should be, with all honesty, as brief, as short, as concise, as precise. Please bear me if I am repeating all these things. Many a case is lost because of bad pleadings. Many a case is lost because of lengthy, unwanted, unnecessary pleadings. Many a case is lost because of bringing in factors which are irrelevant to these particular cause and it is pleaded. It is a war front. You don't give a chance to your opposition to attack you by making yourself vulnerable. You don't give a chance by saying that this is open, please attack me here. You must try to be as precise as you can and see that you are intelligent, prudent, sharp and diligent in your work. I guess I think I should conclude. Madam Registrar tells me she's running short of time. I did prepare something more little, but anyhow, given another opportunity, I can help you. Any questions? I don't think there is time available for that. The next speaker is there waiting, looking at me. Anyway, it's a wonderful opportunity. I enjoyed it. My last bidding sentence to all of you is that please keep studying, please keep reading, please keep learning. Justice S.S. Sundar, in his speech, referred to Nani Palkiwala, the greatest lawyer in India, recognized even by Justice V.R. Krishnaiyer as the best lawyer who's blossomed in this land. If people have an opportunity to read his biography, written by others, or the series of lectures which he has written and published, you will get to know, get to realize, get to understand one fact, that his success, though he was a tremendously intelligent, knowledgeable, great man, his success was mainly due to his industry, his hard work. His hard work that he put in from day one in his practice. A man who finished his MA literature, then came to law, and joined an illustrious senior in the income tax office from day one. I am competent to advise you because I have done the mistake of not putting such kind of hard work in my formative days in my career, and I started putting hard work later. But it is my sincere suggestion, please do maximum hard work. You will get to know many things on your own accord, and that will enable you to grow bigger, rise bigger, and achieve bigger. My best wishes to each and every one of you, my very best wishes to each and every one.
Thank you so much, sir, for sharing your expertise and knowledge with us. I'm very sure that the lessons we learned through your session today, we are definitely going to apply it in our professional endeavors. Thank you so much, sir, for taking time out of your busy schedule and giving us an elaborate view of the art of drafting and pleading within a very short span of time. Thank you so much, sir.